Hi, everyone. My name is Lorraine Galvis, and you are watching the LFW Network. Now that we're back for the new year, I want to kind of talk a little bit about some of the questions that I get from clients and leads on trademark applications, trademark registration. What does it all mean? How do I know it's right for me? When is the right time to start thinking about some of these things for my small business? And these are often questions that I think many of our clients or potential clients have, but initially they're not really looking to a lawyer to get answers to those questions, primarily because they're concerned about cost. Depending on the type of business you're in, it's just going to always seem like there is something else that needs your attention or has to have those dollars invested into it before you even consider getting legal support or legal services. So let's start with one of the most popular questions I get about trademark all the time. And this is particularly for people who already have a trademark registration. And that question is, can I add a class to an already existing registration? In order to add a class to an existing registration, you have to file a new trademark application. So, if you have an existing registration and your company has expanded into other areas of industry or other business services or goods that you're now offering, you do need to file a new trademark application in order to start the process to get exclusive rights to use your slogan or your logo or your brand name in that specific industry area. You're not adding classes to a registration. You are essentially applying for an entirely new registration in that industry category. So essentially, you're going to have more than one registration for the classes of goods and services that you offer. So if this sounds like you and your business has expanded or you've rebranded or you've acquired another company, this is a really good time to maybe reach out to a trusted trademark attorney or maybe someone that a good colleague or friend has referred that has experience with trademark matters for you to be able to kind of ask these questions more in depth. One of the other popular questions that I often get as a trademark attorney is, can I make changes to my trademark application after it's submitted? Once we submit a trademark application, it's done. The fees are paid. There are no opportunities to make any amendments for the time being until we hear back from the examiner. And even when we do hear back from the examiner of your application, there are very, very, very limited instances where you can make maybe a change to your address or maybe a slight change to your description of goods and services. And typically that means taking away goods and services, but you can't add to what's already there. So that's a really important consideration to have in mind. You want to be able to do as much due diligence as you can at the outset so that you're not strapped with these extra legal expenses later down the line in the application process because you didn't bother to really kind of take these careful steps, or the attorney that you're working with didn't carefully kind of review your intake materials and include all relevant services. One key point is, remember, you can always delete services or goods, but you can't add to them. So always remember that when you're filing. When is the right time to file for trademark protection? If you're using a logo to designate or to let people know, hey, we offer this brand of goods or services, or we are this brand, or we are this company, and this is the good or service that we offer to the public. The moment you start doing that, you in theory have a trademark. This is also a very good time to consider registration. I've worked with a lot of clients who feel that a search before applying for a trademark is optional. But at Galvis and Company, we make those searches almost required, highly recommended, but it really, really, really helps the client have a sense of what legal fees are going to be, because we can really give you a sense of what the red flags or the pink flags are going to be way before we even recommend applying for a trademark. So this is really, really important, especially for those of you with businesses where budgets are very limited, cash flow is pretty tight, and we need to really, really be sure of this investment we're going to make in legal services before we make it. Finally, one of the most popular questions that I get all the time is whether owning a domain equals automatic trademark rights. I have another video where I've actually talked about this. And again, sorry to burst your bubbles, but just owning a domain name does not confer any trademark rights on the web domain owner. These are two separate transactions. One is a business transaction where you're just going on a domain website and purchasing a domain. Filing for a trademark registration and actually completing an application and submitting it is a completely different legal process. And in order to get trademark rights, where you would be entitled to use a certain name in connection with a domain name for the web, this is a separate process that you have to go through. And I have been in the position where someone who does have trademark rights to a certain name was able to get someone else to stop using it and to also sign over the rights and sign over the account to the web domain to them. So please be very, very careful. Owning a web domain has nothing to do with trademark rights. And if you're not actually using the mark, owning a web domain is immaterial, has nothing to do with it. A wonderful, wonderful time to decide to maybe talk to a trademark attorney about potentially filing an application. Three instances that I can think of off the top of my head. One, you've come up with a name or concept that you just can't stop thinking about, you're emotionally tied to, and you're ready to scream to the world that this is your brand of goods and services, and this is how you want your audience to know you and be able to find you in the marketplace. If you're having those feelings, that is a perfect time to speak to a trademark attorney and start with a deep dive search. If you or your company are working with a graphic designer or some kind of design concept team on logos for your company or marketing materials, this is an excellent time to reach out to a trademark attorney. We actually have worked alongside graphic designers as they're coming up with these concepts, and we are able to run searches on some of those concepts and names simultaneously so that you don't have to waste your time. If something comes up in our search and it's flagged, you can immediately let the graphic designer know if you have to go in a different direction. And finally, a maybe more pressing time and highly recommended time to reach out to a trademark attorney is if another trademark attorney or any attorney has contacted you regarding your use of a specific logo or brand name or slogan, or if another registrant that already has rights to a certain name, brand, or slogan that you're using has reached out to you concerning your use of what they believe is their exclusive mark. If you've gotten correspondence like this via email or via DMs or any other kind of private messaging on any social media platform, this is clearly uncomfortable. And I'm a small business owner, so I can really relate to my small businesses when you get correspondence like this, whether it's legal or business in nature, from someone you don't know saying, hey, stop using my trademark. That belongs to us and you need to stop. If you truly feel that you are using it legally and that you have a stake, to plant in the ground in terms of your use of the mark, this is a perfect opportunity to speak to a trademark attorney and just kind of get a lay of the land and get a sense of whether you have a leg to stand on. And I think for a simple consultation fee, you can get a lot of your questions answered. So I would strongly advise you to think about that. And also, once you do identify an attorney that you're comfortable with, it feels amazing and so empowering to have good legal counsel at your side that can give you good advice, help you communicate with the other side. I've been in many situations where I've been able to talk to attorneys for other registrants, and we're able to come up with a viable solution where both sides can enjoy use of a certain mark within certain parameters. Please subscribe to our channel, comment in the comments below, and please share your questions with us. Anything you'd like to see us discuss on these videos that's legal in nature or that affects your business in particular, we'd love to get those questions and open them up to be able to give you some good feedback. Again, my name is Lorraine Galvis, and this is the LFW Network. Thanks so much for tuning in. See you in the next video.